Hi there, welcome to the Employment Law Show. You've landed on the right spot. Next half hour, we're going to make you that much smarter when it comes to your workplace rights and employment law. That's what we do and have been doing for years on this show. Greetings, John Scholes here, Lior Samfiru there, lawyer, of course, Samfiru Tumarkin LLP, the most positively reviewed law firm in this country of ours. We're loving that. You can always reach out when we're not doing this half-hour show on your own time as well. Phone number 1-855-821-5900. Dial that when you'd like. Email help@employmentlawyer.ca. And we always send you to the website pocketemploymentlawyer.ca. That is good because it'll give you the details and educate you on so many things we talk about weekly on this show. Plus, you'll have access to the severance calculator. Lior built that a few years ago. Over 2 million Canadians have used it and had their eyes opened up as to what severance really should be. Again, all that's available at pocketemploymentlawyer.ca. Okay, main topic just a bit from now. It's going to be fast facts about temporary layoffs. That's on the way, Lior, but a lot of stuff to get through before that time, including some phone calls from our long-running radio shows. And we always stretch a bit, get warmed up. With the week that was, what do you got?
Hey, John, great to be here. Of course, employment law is the topic here on the show. That's why we call it the Employment Law Show. We wanted to make it pretty obvious, but it's such an important topic. And the reason why we've been able to do this show all these years, every week, is because there's no lack of questions. There's no lack of issues that come up, and we'll never be able to cover all the topics. So if you're ever wondering about your specific situation, there's a pretty good chance that if you watch this show and our other shows, you'll get some answers. But man, the best way to deal with it, frankly, is call me in the office, send me an email. We'll get you all that contact information so we can have that private chat about your specific situation, whether you've just been let go and you're staring at that awful piece of paper, that severance offer, what to do with it, is this legal, should they have even been letting you go? We can talk about that. Maybe your job is changing, something has happened to your hours or your pay or your commissions. Let's talk about that. Maybe you're being bullied, mistreated, harassed. Too many people are in that situation. Well, we can talk about that as well because there are answers, there are solutions, there's things that you can do, and it starts by picking up the phone, sending that email. Again, we'll give you that contact information throughout the show. But a bit of a different situation I wanted to talk about week that was. This is something that I actually see often involving a sale of a business, John. So what often happens in this situation is business is sold, an employee working for the company gets an offer to continue working with the buyer, and the question is what happens then? Well, in this particular situation, I spoke with a lady where, yes, her employer was selling the business. The business is going to be sold, but every employee, including her, got an offer from the buyer. Well, unfortunately for her, that offer was a very different offer in terms of pay and in terms of job responsibilities, even a bit of a different hours of work. So she said, well, no, I'm not okay with this. That's not what I want. I don't want to take a pay cut. I don't want to have a different job, so I'm not going to accept it. So the new company said, well, that's the offer. We're going to withdraw the offer. The old company, the one that she was still working for, that was selling, said, well, we heard that you didn't accept the offer, so we're going to consider that to be a resignation because you had the opportunity to continue working with the buyer. You chose not to. And because it's a resignation, once you're done here, you're done. We're not going to pay you anything. Of course, you can't see John here in the background, but he's shaking his head. And the reason for that is, no, it's not legal. Exactly. It's not legal at all. In this type of a situation, because the offer from the buyer was not comparable, she didn't have to accept it. And the fact that she didn't accept it does not mean that she resigned. In fact, she's being let go. The company that she worked for, because they're selling the business, no longer have a job for her. That's okay. That's a termination. Now they have to pay her severance. And for her, she's been there for over 6.5 years. It's probably about 8 months of severance that she's going to be owed, a significant amount of money. But I wanted to remind everyone, in a sale of a business situation, if the offer from the buyer is not comparable, you may not have to accept it and you can still get severance. Before you reject the offer, before you do anything with it, frankly, call me. We need to do this right. We need to assess it properly. But those rights are very important to keep in mind.
So based on this lousy offer, which she didn't accept, so now she gets severance. She didn't quit. It's not a resignation. Seller pays in that case because, okay.
The company that she worked for pays because they're the ones terminating her employment.
Right, okay.
She never actually worked for the buyer. Now remember, in a sale of a business situation, if you end up working for the buyer, they inherit your service, which is a good thing. So down the road, they may have to account for the full service if they let you go. In this case, she never worked for the buyer. She was let go by the seller, Because of that, she has to get her full severance from that seller.
So day one, she steps foot for the new employer, works a day, they don't like her, they let her go. Now it's their responsibility, correct?
It's their responsibility. They inherit that service. That could be 30 years of service potentially. And of course, that's going to have a significant impact on severance.
Would a smart buyer try to word themselves, contract themselves out of paying that service of 30 years or whatever it was?
A smart buyer like you, now that we've done this show for all these years, absolutely. A smart buyer would want to have the new employee sign an employment agreement that limits their future severance or that limits the seniority that they're carrying forward. So be very careful in a sale of a business situation. If you're going to continue working with the buyer, see what you're signing. Careful with what you're signing. You may be giving up tens of thousands of dollars in future severance. What you want in that agreement is for it to say nothing about your severance. Frankly, for it to say nothing about your seniority. Silence is actually a good thing here. If it talks about you not inheriting service, and if it talks about limiting your severance, those are bad things. We really need to talk about it.
Okay, so one more question. We're getting deep on this one, but new buyer, new contract says we're not recognizing previous service. You say, well, you know what? Then I'm not coming to work for you. Still the seller paying your severance now?
Man, oh man, and there's been many actually legal fights on this issue, but yes, the short answer is yes. If the new company is putting you in a very precarious situation where you don't inherit your service, they don't inherit your service and they can let you go and pay you almost nothing, it's no longer a comparable offer. Meaning if you don't accept it, you lose your job, it's a termination, and the seller has to still pay you your full severance.
In addition to this TV show, Lior and I have been doing radio shows for a very, very long time. We get a lot of great phone calls on the show. You're always invited to tune into the shows and call in as well. Your call may appear on this show. We might talk about it a little bit. Employmentlawyer.ca to find a station close to you, including right here in the GTA. Let's get to our first radio show phone call for the day, Lior, right now.
Well, my brother-in-law, after 27 years at a major printing firm that is owned by a major newspaper, they are closing down and outsourcing their work to another press. And he was there for 27 years. The severance he's getting is only 52 weeks. He just turned 60.
What was his position at the company?
He was operating a forklift at printing to the press.
So many people may say, if they don't necessarily know, well, you got a year, 12 months of severance. Man, that's a lot. Yeah, and it is a lot, don't get me wrong. But the real question is that enough? Well, remember, the main factors that go into assessing how much severance you get is your age, your position, and the length of your employment. And this individual scores highly on at least two of those categories, 27 years of service in his 60s. So that automatically is going to point us to significant entitlement. So spoiler alert, 12 months is not even close to being the proper amount here. Let me show you how much he's owed, and let me show you how you can find out how much you're owed if you're ever let go. We're going to go to pocketemploymentlawyer.ca, and we're going to use our severance calculator tool. We're going to do that. We're going to plug in those numbers, and let's see what we get here. So this gentleman that we just heard from, forklift operator, been there for 27 years, 60 years of age. Company says we're going to give you 12-month severance. Doesn't sound too bad. Well, except you see in the bottom of the screen there, it is bad. He's owed as much as 24 months severance. So that's half what they offered him, half of what he is owed, 2 years. Generally, 2 years is the maximum that people can get. But for him, that's likely the right amount. So even with 12-month severance, that could still end up being a terrible severance offer.
And I'll throw something else in there, and I know you'll probably agree with this, Lior, based on, okay, he's got the years, he's 60, he's got 27 years of service, but at that age, this is not an easy, I mean, he's not a CEO, it's not that hard to get a forklifting job, but it's still a physical gig. Trying to replace that job at 60, good luck, man.
It's tough, and if he's working kind of in the printing industry, maybe, you know, it's less jobs depending on the industry and the specific experience that he may have. And the law understands that the longer it's going to take you to find another job because of any factor, that can easily increase the amount of severance that you're owed.
Again, employmentlawyer.ca to find a radio station close to you that carries our radio shows. We'll get to our second phone call for this show, Lior, right now.
The question was around being terminated inside the 3 months probationary period. Are there times where employers aren't allowed to do that? Was in a maybe more complex scenario than what's worth communicating here, but that's kind of what it comes down to, is just wondering if I have any recourse.
So the first thing I want everyone to understand is that probationary periods are not automatic. they're not. Probationary periods don't exist just because you started a new job. You may think, well, I started a new job, maybe the first month, 2, 3, I'm on probation. No. Probation has to be, for it to exist, it has to be created in an employment agreement. So first of all, if you never signed an employment agreement, you're not on probation. Full stop right there, which means that if you're let go, even in the first 3 months, you are owed severance, and that severance can be measured in months. Yes, even in the first 3 months of employment. So probationary period has to be created in an employment agreement. For you to truly be able to be let go in the first 3 months without any compensation, the employment agreement that you sign would have to say that. It would have to say in the first 3 months, we can let you go without any compensation. If it says that and you sign that, there's not going to be a lot of recourse as long as, of course, the company is not acting in a discriminatory manner. If they could decide, you know, we just don't like you enough, we're going to let you go and not pay you anything. But unless it says that, you're not on probation, that means you're owed severance even in the first 3 months of employment.
All right, that is a good start. We got lots more to go, though, so stay tuned for that. Fast facts about temporary layoffs, and phone call number 3 is coming up as well, so stick around. Here's the reach out information. In the meantime, 1-855-821-5900, help@employmentlawyer.ca. It's the Employment Law Show. We got more coming up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Employment Law Show. I'm John Scholes. He's Lior Samfiru. We're going to do our fast facts about temporary layoffs in just a moment. But as promised from one of our radio shows across the country, phone call number 3 is coming up right now.
I have a friend of mine that is coming up on a new contract. She's being asked to sign this new contract. I went through it with her this weekend. In the contract, it essentially, and it's probably standard in any contract, if you are terminated, you will abide by ESA standards for severance. I mean, obviously, she has to sign it for the new contract. Should she be held to that, or is she still going to be owed way more based on her time?
Okay. I'll pull it up and throw it away.
How much time do we have for the rest of the show? Because this may take me a while, John. There's a lot to unpack here, and there's a lot of assumptions in that call that are frankly not correct. So I'm not even sure where to start, but maybe we'll start with the idea that if you're an existing employee, it's always a bad sign when your employer wants you to sign a new employment agreement. Even if there's supposedly a good reason, I'm telling you there really isn't. And the real reason why an employer may want you to sign a new agreement is because that agreement provides for better terms for the employer. And that's something you have to keep in mind, such as the example here, something limiting future severance. We call this a termination clause. So the first thing I would do here is say, no, I'm comfortable with the way things are. I'm not okay signing a new employment agreement. Now, if you really want to sign it, well, let's negotiate. Let's talk about the things that you're uncomfortable with. A termination clause, a term in the employment agreement that limits your severance could cost you tens, if not maybe hundreds of thousands of dollars at some point. Bad idea. You do not want to do that. And no, it's not standard. It's not something that you should expect, certainly in a more senior role, but frankly in any role, to have an employment agreement. So I would address that with the employer and say, employer, I'm not comfortable with that. I'm not comfortable to give up this severance that I accumulated. That's a lot of money. That's not right. And ultimately, I would not sign an employment agreement in that situation. Now, in some cases, I'll say this very briefly, even if you sign an employment agreement that tries to limit your severance, there could be ways around it down the road. but I wouldn't do that. I wouldn't sign something just assuming that down the road you can get out of it. So best advice is either don't sign or negotiate proper terms.
If someone has signed that agreement, Lior, without watching this show, oops, they should have done that first, but say they did sign it, is it legally binding, I guess, if they don't get something for it? Are they supposed to get something for signing that, a bonus or something like that?
So anytime you sign a contract, there has to be something in it for you. You have to get something in return for your agreement to be bound by the contract. Now, if you're already working for the company and they want you to sign a new contract, well, you're not getting a job because you already have the job.
Yeah.
So they have to give you something else. That could be a one-time signing bonus. Maybe it's a promotion. Maybe it's a pay raise. Maybe it's extra vacation. Something in return for signing. If they simply say, you know, we're not giving you anything, we just want you to sign this piece of paper. Happens all the time, by the way. That's not going to be enforceable, but even in that situation, I'll be very hesitant to just sign something. Always the best advice is if you can't live with something, well, let's not sign it. Let's try to negotiate something different.
Main topic, as mentioned, fast facts about temporary layoffs. Fact number one is this: temporary layoffs are not permissible for any length of time unless an employee gives their consent. That's going to shock a lot of people.
Every single week I get contacted by individuals asking me, well, how long can my temporary layoff last? Or my employer said, I'm going to be off for 10 weeks. They extended it to 12. Can they do that? Well, the answer always is they actually are not allowed in most cases to put you on a temporary layoff at all, whether it's for a week or 10 weeks or any other amount. In most cases, a temporary layoff gives you the right, gives the employee the right to consider that a termination and get their severance. It's up to the employee. Now, of course, you can consent, you can agree to a temporary layoff and accept that layoff if that's what you want, but you don't have to. So even though the company is not letting you go, they're not saying, we're firing you, you can choose perhaps to consider that temporary layoff as a termination, as if they let you go. So that's an option that the employee has, regardless of what the company intends on doing.
Fact number two about temporary layoffs is this, Lior: an employment contract may contain language addressing that temporary layoff.
The employment agreement, we were just talking about it, how it could certainly be very problematic if you just sign something without knowing what you're agreeing to. One of the things an employment agreement can do is give the company the right, the power to put you on a temporary layoff. The law says you can't do that unless you agreed to it. So if you agreed, you sign an agreement saying, no problem, employer, if you ever want to, you can just put me on a temporary layoff, well, then the company can do that. So be very careful. It's a terrible term to have in an employment agreement. That may mean the company can put you off work for months at a time, anytime it wants. A very big deal. Don't ever agree to it.
Saw that in the pandemic over the last 3 years, right? Perfect example there. And that kind of lays into number three. It says employees, in fact, it's reducing their rights if they accept that temporary layoff, right?
Well, I've just said that an employer doesn't have a right to put you on a temporary layoff in most situations. But if you accept it, if you allow it to happen, you sit at home and then you go back, by doing that, you've affected your rights. You've given them the right to do it again. So you thought maybe it's a one-time thing. I'm going to be that good soldier. I'm going to accept that temporary layoff and go back to work. Obviously, that's admirable. But by doing that, by being that good soldier, you've given them the right to do it again and again and again. And the next time they do it, and the 10th time they do it, you may not be able to do anything because you let it happen that first time.
We're going through our temporary layoff fast facts. If you remember nothing else from this segment, remember number four: a temporary layoff is a termination. Right?
A temporary layoff is a termination if the employee wants it to be. And of course, with the temporary layoff, it's in that employee's discretion. Company often says, oh, but what didn't you understand, employee? We said temporary. We didn't say permanent. Don't you know how to read? Well, no. The employee can choose to consider that a termination. There's no automatic right to put someone on a temporary layoff.
Well, we often say, you know, 50% pay cut is 50%. Temporary layoff is how much?
100%.
It's 100.
Yep.
Yep. Fast facts. Number five is this, Lior: severance packages for temporary layoffs can be as much as 2 years' pay, 24 months.
So because the law considers it to be a termination, the law considers, again, constructive dismissal. We talked about that on a recent show. By putting you on a temporary layoff, by putting you off work, by stopping paying you, the law considers that to be a termination. The same rules that apply in a regular termination apply in terms of your severance. You could be owed months and months severance, up to 2 years of pay. In some situations, even a bit more than that. So you can use our Pocket Employment Lawyer.ca tool. Our severance calculator is there to find out how much you're owed. Same rules apply.
More of your questions are coming up on the other side of the break. We'll get into that now and return as quick as we can. In the meantime, here's that number, 1-855-821-5900. Email help@employmentlawyer.ca, and always pocketemploymentlawyer.ca as well. For any other reference material, it's right there, free and anonymous. More of the Employment Law Show is coming up. Stick around.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back. Thank you so much for sticking around. Employment Law Show, John Scholes, Lior Samfiru. To reach out before we carry on, here's the phone number, 1-855-821-5900. You prefer to email. That's also something else you can do, help@employmentlawyer.ca. And here's another one for you, terminationquestions.com. We love this because it's free, it's anonymous. You can ask your questions there anytime, and they will get answered off camera, on the radio, off the radio as well. We'll do one right now. Lior says, I was recently diagnosed with arthritis and have spoken to my boss about accommodation at work. However, he refused my requests. I have since received unusual negative criticisms about my performance. I'm worried I will lose my job. What can I do?
So there really isn't or shouldn't be such a thing as refuse my request. Now, what I may be reading here is that the requests were made by the employee, that the employee went to the employer and says, hey, employer, do me a solid and provide me with accommodation. That's not the right way to ask for accommodation. The right way to ask for accommodation is with a doctor's note. That request for the accommodation needs to come from your doctor. He or she needs to say, here's the accommodation that's needed. By the way, your doctor doesn't need to say what your medical condition is, what your diagnosis is, but they can say you need to work 20 hours instead of 40, or you need to work from home, or you need modified duties where you don't lift more than 10 pounds. They can absolutely do that. And once your employer gets that doctor's note, they have to accommodate. They have to do everything in their power to provide that accommodation if at all possible. And if they don't, that's a human rights violation. So that's a good starting point, that doctor's note. Now, if the employer won't accommodate, human rights violation. If they go the extra step and they penalize you because you ask for accommodation or because you have a medical condition, an even worse human rights violation, you have protections of the law to prevent that from happening. But always start with that doctor's note.
And a good employer really won't argue. In fact, my wife broke her elbow a couple weeks ago, and the employer was actually very proactive, saying, no, here's your accommodation. You got to stay home. Don't do this. She's like, I can come back. Like, no, you're on modified. Do what you need to get better, right? And a good employer should do that, right?
A good employer should absolutely do that. But a cautionary note there. An employer should also not decide on their own what the accommodation is. If the employee says, no, I'm fine to work and my doctor's not giving me any limits, the employer shouldn't say, well, okay, we're going to reduce your hours because we think you need accommodation. It should always be driven by the doctor of the employee.
Again, you can ask questions live streaming on Facebook and YouTube. Lior takes part in that every week at stlawyers.ca, at stlawyers.ca to take part. Here's this week's question, Lior. A year ago, I was approached with an offer by a major competitor of the company I worked for at the time. I took the position, but now there are indications I might be let go. If terminated, would my severance or payout take into consideration the 12 years spent with the previous employer?
Yeah, so this is a question that's extremely important, actually fairly common, and something we absolutely need to discuss. And we've touched on this before, and that is the idea that if you're recruited from a secure job, you're not looking to leave, they knocked on your door, they came after you, and they convince you to leave. Well, in that situation, if you're let go in the first, let's say, 3 years or so, you may be owed enhanced severance that recognizes some or all of your service with the previous company. So you may have only been a 1-year employee with the new company, but because they recruited you, we call this inducement, they induced you to leave that secure job that you had for 12 years. Now, when they're letting you go, you may be considered a 13-year employee, the 12 with the old company and the 1 with the new company, and should be getting severance as a 13-year employee. And because of that, the amount of severance that you get could actually be greater than the length of employment that you had with the current company. So a few things to remember in that situation. Obviously, it only applies if you're recruited. If you're applying for a job, if you're sending out resumes, this inducement factor really is not going to be a key. The other thing is probably very important. We touched on employment agreements. Here's that term again. Be careful with what you sign. If you sign an employment agreement with a new company that says we're limiting your future severance, or we're telling you explicitly that we're not going to recognize service with the previous company, then you don't get that benefit of the inducement. Remember, if the company is recruiting you from another company, they probably want you pretty bad. They probably decided that you're the right employee for them. So in that situation, you have some bargaining power. You can negotiate good terms of employment. So take advantage of that, okay? Don't just sign anything, something especially that could cost you tens of thousands of dollars.
All right, good stuff. Again, questions that arise during the show, 1-855-821-5900, help@employmentlawyer.ca. But we love this segment. To wrap it up again, it is the Employment Law Show Rapid Fire Questions. All right, Lior, here we go. We're going to get through them right now. Can my employer, that's how every question is going to start. Can my employer ignore my complaints of bullying and harassment?
Cannot ignore complaints of bullying and harassment. They have to be taken seriously. Your employer has to investigate and ultimately make all efforts to rectify that harassment. There's no middle ground here. There's no saying, oh, it's up to you, boys will be boys, all these things that we used to hear about years ago. Take it seriously if you're the employer, investigate and fix that problem.
Number 2, can my employer make me retire at age 65?
So, gosh, 23, something like that, years ago, mandatory retirement was abolished in Ontario and across Canada. And because of that, we don't have mandatory retirement. You can work until whatever age you choose, whether it's 65, 75, or any other age. And I've spoken with many individuals that were working into their 80s. Amazing. Good for them. Your employer cannot force you to retire, cannot decide when you've had enough, cannot tell you that they want someone else younger in the workplace. That's age discrimination, a human rights violation. You can make that decision for yourself. Anytime your employer puts pressure on you or decides for you, that's illegal. You have to give me a call.
Rapid fire question number 3. Can my employer swap my job with a colleague?
Well, I was going to say no, but it really does depend. Because if at the end of the day, if they swap the jobs, but the new job you're doing is fairly similar to what you were doing before in terms of responsibilities, in terms of hours of work, in terms of pay, then yeah, your employer can do that. You may have preferred the old job better, but if it's similar enough, they may be able to do that, and that's okay. Now, if the new job is very different, well, it's different hours. I used to work weekdays. Now this new job is weekends. Or I used to work days. Now we're looking at afternoons. Or the pay is different, then the answer is no. That's a constructive dismissal. Your employer can't do that. You could treat that as a termination of employment. So if you're not sure, can my employer do this? Is this a big enough change? Just call me. We can talk about it. I can tell you.
Question number 4, can my employer request I return to working in the office after working remotely?
Generally speaking, yes. Let's say during the pandemic. If during the pandemic your employer moved you and your colleagues to work remotely because of the pandemic, they can require in most cases you to come back to the office. Now they do have to give reasonable notice. They can't just say tomorrow, but in most cases your employer can require you to go back to the way things were pre-pandemic.
Rapid fire number 5, lowering my pay or hours as a disciplinary measure. Can they do that?
No, they cannot. Your employer cannot reduce your pay. They cannot lower your position, demote you because of disciplinary measures. They can provide you a warning, maybe even a paid suspension in some cases, but anything other than that is offside.
And finally, rapid fire question number 6 goes like this, Lior. Can my employer fire me for comments made on my personal social media account?
They can. If it impacts the workplace, if it impacts how others may see you or the employer's reputation, they can let you go. So assume that there's no such thing as privacy online. There's no such thing as privacy in social media. Very important to remember that.
Made it through. Another rapid fire is done for this week. Thank you so much for joining us, sending in your email questions as well. You can always reach out to Lior and the team now that we're done. Phone number 1-855-821-5900, help@employmentlawyer.ca through email, and pocketemploymentlawyer.ca as well. We'll catch you next time.